Welcome back, everyone. The recent lecture in our discussions has motivated me to conduct some research on my own to further understand intellectual property. Several important elements and decisions are placed into effect while starting a business, and thus it is not uncommon for items to become overlooked. Unfortunately, one element that often gets overlooked is a company's intangible assets, both current and potential, and that oversight can be very costly, especially over the long run. Failing to identify or even understand the value of these assets can be very risky and can cause one to lose funds from investors or fail to protect one's intellectual property. Consequently, today we will discuss the top 3 intellectual property mistakes that are most commonly made and their harsh realities. These truths will relate one to the consequences of not accounting for all variables in one's startup. Let's begin. Mistake number 1. Failing to thoroughly conduct research upon one's idea. Because of this mistake, startups oftentimes fail to recognize similar companies or existing products and perhaps even existing registered IPs related to the creation. Assuming they will never deal with IP-related problems, some companies do not ever establish any form of IP strategy in case any unforeseen issues may arise. It is truly important to stray from the path of ignorance and address this vital research component of one's company. Mistake number 2. Failing to understand the means to protect one's intangible assets. It is common to hear enthusiastic entrepreneurs state that they will file a patent on their idea without any clue as to what type it may be. The forms of intellectual property can have different importance and overlaps for creations of different industries. Oftentimes, companies fail to understand these differences and similarities between copyrights, trademarks, trade secrets, and patents. And this can become the biggest mistake for a company when it comes down to protecting one's intellectual property. By using the wrong type of protection of rights, one could indirectly permit other entities to utilize the intellectual property without any legal accountability. Sometimes some startup businesses proclaim that they do not have a need to register their IP. Refrain from believing the following. I am not looking for a fight. I don't have the money. I will do it when I need to. I have more important things to do and focus upon. I would not have the money to enforce my rights anyways. It's okay, I have got an NDA, which is a non-disclosure agreement. So definitely refrain from thinking any of these thoughts. Mistake number 3. Failing to establish a futuristic IP strategy. More specifically, this mistake refers to a business's oversight in believing that they need not worry about IP after the early stages of their business when they have already established a position that is sufficient in avoiding infringement upon other property at that time. Contrary to such backward ideology, a solidified IP strategy for a successful business consists of an ongoing tactic. This strategy must be updated routinely to reflect new ideas and products that the company develops. This is vital, often overlooked measure for developing businesses. An important thing to note is that an IP should not be publicly disclosed before deciding and executing on strategy. The following are some examples of risky disclosures that you may overlook. Presentations at conferences, research abstracts presented in a public forum, posting of information on websites, publications, meetings with company representatives or colleagues. In the next video, I will elaborate on some steps to take in order to ensure one avoids making such costly mistakes in one's IP adventures. The fruitful outcomes of taking such measures will also be discussed in great detail. So stay tuned and I'll talk to you soon.